Well, I find that Matthew Neil Aldridge has failed to appear in personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally.
This defendant thought a stack of sovereign citizen paperwork was about to stop a criminal case in its tracks, but the judge immediately sees what's happening and delivers a brutal reality check. What starts as a bizarre challenge to the court's authority quickly turns into one of the most direct shutdowns you'll ever hear in a court.
Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact.
Alright guys, this hearing starts getting strange almost immediately. A man appears in court claiming he's not actually the defendant, but instead an attorney in fact speaking on someone else's behalf. The problem? The judge isn't buying it for a second. What follows is a classic sovereign citizen-style confrontation filled with jurisdiction arguments, legal buzzwords, and paperwork that the court says means absolutely nothing. And as you'll see, the judge wastes very little time shutting the entire strategy down.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court.
Right away, the judge is trying to determine something very basic: who is actually standing in front of him. Instead of answering directly, the man introduces a completely different argument about being an attorney in fact. The problem is that criminal court doesn't work that way. You can almost hear the judge realizing he's about to deal with one of those arguments that sounds legal on the surface, but falls apart under scrutiny. And this is only the beginning.
You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here. All right. This is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary.
Now the paperwork comes out. The document challenges the state's standing, references corporations, legal maxims, and civil court cases, and essentially argues that the criminal case should stop immediately. This is where the hearing takes a major turn. Because instead of being impressed by the document, the judge begins identifying problem after problem with it. And once he finishes reading it, the defendant's entire strategy is about to collide with reality.
And the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are in fact Matthew Neil Aldridge, you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on a...
This is where everything changes. The judge directly states that he recognizes what is happening and calls it a sovereign citizen approach. Then he explains something viewers hear over and over in these cases. Simply filing unusual paperwork doesn't erase criminal charges. The judge makes it clear that civil cases, corporate theories, and internet legal arguments have no effect on the criminal prosecution before the court. And you can feel the momentum completely shift away from the defendant at this point.
What we call our last plea day before his trial date tomorrow.
Is that an article pre-trial?
To what?
Would that be an article pre-trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop when I'm finished talking. You are wasting the court's time by doing this. And I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge.
At this stage, the judge isn't just rejecting the argument. He's becoming frustrated with the constant interruptions. Every time the judge attempts to explain the situation, another question or challenge follows. That only makes the situation worse. Instead of gaining control of the hearing, the defendant is losing credibility with every interruption, and the judge is getting ready to make that crystal clear.
All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. the last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th.
This is the final reality check. The judge declares the filing invalid, rejects the argument entirely, and moves the case forward anyway. Then comes the warning. If this person really is Matthew Aldridge, he must appear and deal with the case properly. If not, the message still reaches the defendant: show up or risk bond revocation in jail. In the end, none of the paperwork changes the case, and the court proceeds exactly as it intended.
July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on revocation will take place, and his case will be set, will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
This hearing is a perfect example of what happens when courtroom arguments focus on technical theories instead of the actual criminal charges. The judge repeatedly gave opportunities for a straightforward answer, but the hearing kept circling back to paperwork and jurisdiction claims. In the end, the court rejected the filing, kept the case moving forward, and warned of serious consequences if the defendant failed to appear. Do you think the judge handled this exactly right, or should he have spent more time addressing the defendant's claims? Let me know in the comments, and subscribe for more real courtroom drama and sovereign citizen courtroom showdowns.